Alright, guys. I like to start about a quarter after just to make sure that we can get everybody out and on the road and so we can get back to work by 1. So thank y'all for coming. Y'all know me already, Trip Watson. Also want to introduce Jamie Costin, classmate of mine at Cumberland. All she does is estate planning work. I tell a lot of my folks, when you're getting out, when you're getting into business, you need to start immediately thinking about what your exit plan is going to be. And while I help manage the exit plan, after that, what you do with your personal assets, what you do with your family and whatnot, I don't touch that. I refer it to Jamie. So, everybody, please welcome Jamie.
Thank you. Good afternoon. I am Jamie Costin, and I'm very grateful to Trip for having me today to kind of talk about a couple of estate planning things and a lot of mistakes that people may make when they are estate planning. Well, the first question you might ask is, what is an estate plan? I consider an estate plan your last will and testament, a durable power of attorney, and a living will or an advance directive for health care. And those are kind of the same thing. They're interchangeable for the most part. So that's what, if you say, I want an estate plan, that's what I would include. I don't really piecemeal them. I think it is a package deal to have all of that because the will obviously will come into play after you pass away. The durable power of attorney takes care of the business of life if you're unable to carry it on for yourself, and the living will and advance directive for health care allows your family to make the decisions that you would make for yourselves in the event that you cannot speak for yourself. So when people think about estate planning, there are often a lot of problems that come into play. And I run into those a lot because I represent children in estates that have already come to be in court. And so I get to see a lot of mistakes that other lawyers or people who haven't sought out lawyers or made estate plans have made. So I'm going to share some of those along the way as well. The number one mistake people make when planning their estate is not planning their estate. Everyone who does not have an estate plan has a pretty good excuse as to why they don't. Most people might think they're too young, they're too healthy, it's too expensive.
They don't have enough stuff.
They don't have enough stuff. They don't want to think about it. It's morbid. I'll get to that later. There's a lot of excuses that come into play, and I don't really like the word excuses because it has a negative connotation. But I mean, there are good reasons why people don't do it. And there are several instances when you need an estate plan. One is if you have children. That is the first and foremost, most important thing. If you have children, you wouldn't drive around in a car without insurance. You wouldn't have them live in a house that's not insured. Well, this is a different kind of insurance, and it's almost insurance with an E. You're ensuring that your children will be taken care of if you can't be there to take care of them for whatever reason. That is the number one problem is people do not have an estate plan. Another problem people have is they think, well, I don't really need a will because if I die, everything will go to my spouse. And in some cases, that is true. But if you die without a will in Alabama, we have a nice handy-dandy set of laws that determine, depending on how much stuff you have, who gets what. And sometimes it would all go to the spouse if it's a very small estate. Sometimes it goes to the spouse, split with some children. And it just depends on the structure of your family and the amount of the net amount of the estate. I was on a case about a month ago where I was representing a 3-year-old child. And the child's mother was the widow of the man who passed away. He had no will. His house was underwater, his car was underwater, and all he had was a money market account with $30,000 in it. He had a previous marriage. Hello. Oh, you're good.
We've now reached our limit of attorneys.
He had a previous marriage with 2 children. So he had 3 children total and a widow and an ex-wife, with the only assets in the estate being the $30,000 money market account. Well, because the house was underwater and the car was underwater, those don't count. So because he had no will, the wife, under the law that the legislature decided, the wife got half of that, and then the children split the rest. So whereas he could have planned ahead and maybe had his property sold and satisfied the mortgage and maybe had a little bit of extra, instead the children each received $5,000 from their father's estate, which is really not the best.
All went to the attorney.
And yeah, and then, well, I got paid first before the kid gets anything. So that's a very just sad thing where if you had done a little bit of planning ahead, the children could have been taken care of a lot better than they were. And speaking of children, yes,
Can I ask a question?
sure.
What's the net value of the state where you have to split it up between the spouse to get it all? I mean,
I think it's the first, and there's all kinds of caveats. I think the first $50,000 worth of the estate would go to the spouse, and then depending on who's the parents of the common children. I mean, there's like little caveats for if you have a surviving spouse. If all the children are this common between the surviving spouse and the decedent, then it splits a certain way. If there's children by other people, it splits a certain way. And I can look that up for you and know exactly, but it differs depending on family structure and value. But I think it's $50,000, which is not very much when you consider that the value of the equity in your home and all of that stuff is also included in the.
That's news. I've never heard of that before in Alabama. I've heard of it in like Louisiana. I've never heard.
There's some they're called intestate law, so it does come into play, and it'll eventually come around. So it's better to plan ahead. And speaking of children, another problem people have when they're planning their estate is that they will just say, well, okay, well, if I can't leave it to my spouse, I just want my kids to have it all. Well, in Alabama, children are children until they're 19, and children cannot inherit property or substantial sums of money until they reach that age. So if you were to leave a certain amount of property or money to a person or to a child, it would have to go through the probate court in the process of a conservatorship. We'd have to set up a conservatorship, which is just it's not a difficult thing to do, but it's one more step, and it can get expensive, and the court monitors the conservator who's in charge of the stuff, and it's a drawn out process, and when you're dealing with a death and a will and distributing all the stuff, it's one more step that is easily avoidable that you don't want to have to do because it's just going to be just a pain in the neck to do. It's not impossible, but if we can avoid it, we can. And within a proper estate plan, you can't avoid that. So what we would do in that case is in your will, I would set up a testamentary trust. And in your testamentary trust, you would leave your property to your child, but it would be held by another person, a person that you would call your trustee, the person you trust to take care of your child's property until they reach a certain age. And I usually recommend 25. Some people like 21, some people like 40, just depending on what you have and how you trust your kids. But the trustee manages the property until the child is old enough to take management of it himself or herself. And that means that if little Johnny needs braces, the trustee can release the money. Or if we need college tuition or books, or if you want to buy a car or they need clothes or whatever they need, their needs will be taken care of. They just don't manage the money for themselves until they reach a certain age. And I highly recommend that tool because it's so much simpler than going through that conservatorship process. Another a common estate planning problem people have is that they will just say, okay, well, I'm going to just leave. I'm going to put my kid on my bank account, which is not a bad idea. And some people I highly recommend, if you put your kid's name on your bank account, this is not a probate asset anymore. It doesn't go through the court. It goes straight to them upon your death. Well, here's the thing with that. You put somebody on your bank account, they're a joint owner on that account. So that money is just as much theirs as it is yours. So if your child who is on your bank account has a credit problem, their creditors can come and get your money out of your bank account. So depending on your level of trust with your family is how I would advise to go with that, and your fiscal soundness, I guess, would be a good way to, and their fiscal soundness would be a good way to measure that. But a good way to avoid that is through the power of attorney. That would only grant them specific access at specific times, and that would be generally upon the time where you are not able to make your own decisions or conduct the business of life for yourself. So depending on your own personal situation would be how I would advise somebody to either put somebody on your bank account where it wouldn't be a probate asset, or to have the power of attorney for situations where people are not necessarily as responsible with their own money as you would like. And that kind of goes into the next thing, which is if you have something that you would like to give to your kid, and I can't tell you the number of times I've sat down with people and they've been like, well, I have this son, but he's good for nothing. Or I have someone, they're not good with money. So you can leave your good for nothing son some money in a trust just like you would for a child and have somebody else manage it for him. Or if your daughter's not good with money and she just spends it all, like I would like to, but I don't. You can leave that money in a trust for an adult as well for, whatever money they need. They just wouldn't have complete control over it if you just don't want to pay their debts off with it. And that kind of goes into the next thing too, which is making sure that all of your life insurance, if you have an existing will, whatever you have, making sure that everything in it is current. A lot of people, I have a will, and I sat down with some people this week, and they're sweet, sweet people, and I looked at the date of their will, and it was about 6 months before I was born. And I was like, well, we might want to update this, because I was asking them about I knew they had grandchildren, and they said, well, all of our grandchildren are in their 20s. And I was like, okay, so it's time to they had named guardians for their children, and now their grandchildren are adults. So I was like, it's time to maybe just update it to make it the most current. Also, this kind of life insurance, make sure your life insurance has current and proper beneficiaries. I had a client who passed away who had his father as his beneficiary, and his father had passed away. So we get a check to the estate. Well, he had no children, and everything he owned was joint owned, so he didn't have an estate. So we had to get the insurance company to try and issue new checks to the next of kin, and it wasn't difficult, but it was another hoop, and it cost him money to pay me and to do all of that. But make sure all of your beneficiaries, your trustees, your guardians for your children are all current, and have it reviewed every so often. It doesn't have to be every year, but if there's a change in your life, you may want to go back and revisit your documents and say, okay, I've left my kid to this person or my sister, and I don't talk to my sister anymore. I would not like for my kids to go to her, so you might want to change it to something else. And that's easy fix, but it can cause a problem if that document came into play before you're able to get it fixed.
I was going to say divorce is one of those change in life that you
Yes.
need to make sure, especially on life insurance policies or 401ks.
Absolutely. Divorce is a very good example. I do believe under a will, the presumption of law is that if you leave everything to your ex, the presumption of law is that person predeceases you. But still, it's a good idea to have it clean. Divorce is a good thing. Death of anybody who you name as a beneficiary. I try really hard to have contingencies, like if this happens, so that there's really no holes in the will or holes in whatever we're doing. But a lot of times that happens, and like I was on a case this week where there were so many holes in the will because there was nobody left who was a viable executor that actually didn't even put the will in probate because there was really no point. So they're just proceeding as if there was no will. So
Jamie, is there a reverse will? I mean, if somebody has a lot of debt and they don't want that to pass on to their kids or grandkids, because I would think that if your parents had a lot of debt, you could assume that when they die.
well, okay. There was not a legal document that's like a reverse will, but in that instance, you probably would not open an estate. If you don't have anything to pass, you wouldn't open an estate. So the creditors would be suing the estate, and if there's no estate, then unfortunately for the creditors, they're probably just going to have to write that debt off.
All right, well, I want to thank Jamie for coming here, and I want to make sure everybody gets out of here on time. So feel free to network and meet everybody else and finish up your lunches and whatnot. And again, Thanks, Jamie.
Thank you for having me. I appreciate it.